Hi, I'm Mari Frank, and today I'm going to talk to you about negotiations and ethics in settlement. And this is an important skill for all of us to know. I'd like to start out with a quote by Abraham Lincoln when he was speaking to lawyers in the 1800s, and this is what he said. He said, "Discourage litigation. Persuade others to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees, expenses, and waste of time. As a peacemaker, a lawyer has a superior opportunity of being a good person. There will be business enough." Even though that was spoken in the 1800s, it still holds true today, doesn't it? If you go to litigation, you don't settle early, it's going to cost a fortune. And if your clients are spending a lot of money and they're not getting what they want, you're not going to get paid. So it's really important that you start thinking about negotiation. Most of what we do all day long is negotiation. Think about it. You negotiate with the court, with the clerks, with your staff, with your clients, with opposing counsel, and then when you get home, then you negotiate with your spouse or your loved ones or your kids. So this is an important skill, yet in law school it's still not even a required subject in most law schools. So this is something that you have to think about now, and the ethics are very important as well. In fact, we know that for those of you who've been practicing now, you have probably met really wonderful attorneys who are ethical, they act in good faith. When they say they're going to get you something, they get it for you, they don't lie. And then you've probably also met bullies. You've met attorneys who don't act in good faith, who delay, who don't provide documentation, who literally lie. So we want to help you to be the best attorney you can be by being ethical. And these are our ethical duties really relate to several aspects of the law. And let me give you some of the things that we're going to talk about, not in depth, but a little bit. First of all, we're going to talk a little bit about the Attorney General Guidelines of Civility and Professionalism, the Business and Professions Code, the Rules of Professional Responsibility, the Evidence Code, and the California Rules of Court. Let me start out with the Attorney General's Rules of Civility. It's amazing that we even have to have those rules. I'm going to just give you a couple of those. One is that you must advise a client at the outset of the case about alternative dispute resolution and consensual dispute resolution. You must de-escalate the conflict and the hostility. That's your job as a peacemaker. You must not delay, and you must act in good faith. And there's many more aspects of this, but I just gave you some of the top ones. Then there's the Business and Professions Code 6016, and that says that if you misrepresent facts, what you're doing is you are committing moral turpitude. And as you know, moral turpitude is grounds for disbarment. So you must not misrepresent facts to your mediator, to your attorney, to the other attorney, to the judges. This is very important. Now let me explain the difference between misrepresenting and puffery, because that's been with the State Bar. And puffery and puffing is when you talk about an opinion for settlement. For example, you might say, "My client can't settle for less than $150,000, and then you settle for $80,000. That was puffery, okay? You weren't misrepresenting. You were talking about an opinion. However, lying and misrepresenting would be something like, "My client has no insurance," when in fact they do have insurance, and maybe hundreds of thousands of dollars worth of insurance. Or you might say, "My client only makes $50,000 a year," when they make $150,000 a year. That's misrepresentation. Okay, another Business and Profession Code 6128 talks about deceiving or delaying settlement, which we know happens all the time, and that's considered a misdemeanor. Let's talk a little bit about some of the State Bar Rules of Professional Responsibility. You've got Rule 2-100 talks about communication with a represented party. As you know, you cannot speak with a represented party unless the other attorney allows you to do that. Now, it's often assumed when you're all sitting around in a group negotiation that that's okay. The same thing in mediation. It is assumed most of the time that if you're in an open session that you can speak with the opposing counsel as well as the opposing client. But anytime the attorney says, "Do not speak to my client," you have to stop. So that's very important. And now with social networking, you have to be very careful about indirect communication. Rule 3-510 is the communication of a settlement offer. You must provide documentation or correspondence or any offer, whether it's in mediation or negotiation, of all of your settlement offers. Even if you think it's a terrible offer, even if you think your client is going to blow up at you about that offer, what you have to do, you still must relate it to your client. But what you can do is you can tell them, listen, this is just a proposal. You can propose anything else you want. So that's a very important issue, because I know in mediation, and I'm a mediator, is I sometimes hear the attorney say, I don't want to tell my client what they offered. They'll just flip out. That's just not, it's illegal for you to do that. Then the California Evidence Code 119 really affects mediation. Now, this is very important. Anything said or prepared for mediation must be kept confidential. And that means that no writing that you prepare, and for example, if you have a forensic accountant value a business, if it was prepared for mediation, you cannot bring it to court. It is not allowed into court unless everybody agrees and changes it and says we allow it and it is enforceable in court. Finally, any writing that you have, if you want it enforceable in court, the language must say, we've agreed to X, Y, Z, and we agree that this shall be enforceable in a court of law. If it doesn't say that, I don't care if all your clients have signed it, everybody with authority to sign it, it is not going to be enforceable in mediation. And finally, who should you bring to mediation? The California Rules of Court 3.894 say you must bring someone with authority to settle. Now, the mediator may excuse that person and they may appear by Skype or by phone, but they must be there and they must sign the agreement. Now, as a mediator, I've had sometimes people will come and say, yes, I brought someone with the authority to settle, and then at the last minute they say, oh, we don't have the authority, that person is out of town. So that is bad faith. And I want to just leave you with 5 keys to remember how to really be an effective ethical negotiator. And these are easy because I'm going to give you an acronym, POWER, P-O-W-E-R. P stands for preparation. If you prepare and you know your case, you know the law, you know the facts, you know the opposing counsel, you know the other client, you know your client and what your client is going to say, the more prepared you are, the more successful you're going to be. And if you're not prepared, you're going to bully the other side and you won't be ethical. So that's a huge point. O stands for options. Come in with options. If you say my way or the highway, you're not going to get a deal. So it's important that you have options that we're going to meet your client's needs and the needs of the other party so you can get a mutual gain. W, worthiness. Are you trustworthy? Trustworthy means you say what you're going to do and you do it. You don't lie, you're honest, you're open, and you're going to be respected. Next one is ethics. Ethics go to the issue of, are you going to bully? Are you going to act in bad faith? Are you going to play tactics? Are you going to play games? If you do that, you're not ethical. And you know what? Now that we have all these listservs and we have social networking and this is a small world, if you have a bad reputation with one attorney, you will have a bad reputation with many attorneys. And it's going to follow your entire career. So don't do it. And last, relationship. Build relationships. People want to do business. People want to resolve issues with people they like. Judges want to, you want the judge to like you. You want the other attorneys to like you. And I want to leave you with this. In 1984, retired Chief Justice of the U.S. Supreme Court, Warren Burger, said this: lawyers, judges, law teachers, the entire profession has become so mesmerized with the stimulation of the courtroom contest that we tend to forget that we should be healers of conflict. I want to recommend to you that your clients will love you if you're a healer of conflict, if you really help them to resolve their case easily and effectively and cost effectively. And I'll tell you one other thing. As a mediator for the fee dispute in Orange County, California, those clients who are not happy don't pay. So just be ethical, be good, and be a peacemaker, and you'll make it in this world as an ethical negotiator. Thank you.